Pardon me, miss.
Yes, item number 1.
Item 149. It's a matter, my lord, regarding the 13(4) matter, Surface Act. My lord, 3 weeks continuously it is coming, but it is not that. That matter, my lord, was directed government to take instruction why you have not taken action so to give the in 60 days. So it is for that reason it is there. So I pray that let it be come in the supplemental list, then it can be 149. That is against the collector Hon'Ble. This one. Tomorrow or day after? So we can list it tomorrow in the supplementary list and verify if any instruction has come. Obliged, man. Obliged. Item 152. Just item 149. Just mention.
If my paranormal
petition of land. This matter tomorrow, that is 28 2020.
well, item 53, Miller. This is also same 13(4) item. 13(4) matter. Kindly you've taken the first half.
53.
53, item 53.
So where you mentioned
first half. Well, but tomorrow is the.
It may reach, sir, we'll see that, yes.
My lord, item 152 in the weekly list. That is a covered matter.
Give that judgment to the London State Council, let him verify. If he says that it is a covered matter, it can be taken up. Okay. Okay.
Item 1, my lord, I pray for the last August, my lord, Saturday. Item 1.
Yeah.
At shall also be taken up. I have those judgments, my lord. I have gone through this.
We gave you some judgments last time to examine all those decisions.
My lord. I have gone through this and I have also taken some judgment, my lord, that is in favor of us, so that will also be taken up of that.
Want it all?
31st of Saturday, my lord, August.
31st is working.
Yes, my lord, this time.
No, let it come on 2nd. The London Council, you are for the petition. The London Council for the petition submitted that the matter may be taken up next week to find out some latest decisions on the points which are mentioned in the order dated 28/2024. Put of this matter on 2nd of September 2020.
It will be add, my lord.
It will be in that week.
My lord.
My lord, item 23, and we permitted.
Is it 9/20? Yes.
Item 23, my lord, is fresh matter, and we permitted to serve a copy on the bank.
See that. Let the matter be.
Item 2. But these two matters and your inaction of the state opposite parties in not paying them
though this first appeal, my lord, under Annexure 1, have been settled by this Honorable Court in Lok Adalat and page 8. And thereafter, my lord, in 2010, thereafter it was calculated and by the court below. Thereafter, no payment till today, my lord. And last occasion, they have directed to take.
It was disposed of on 17/12/2010.
My lord.
Okay, you come to page number 8.
My lord.
The operative
That is,
part.
accordingly, this appeal is disposed of in Lok Adalat spirit by fixing compensation at 18,000 per acre. The trial court is directed to calculate the compensation. The total compensation about calculated by the trial court be deposited by the respondent before the trial court within 3 months from the date of such calculation.
Yes.
Urgent certified copy.
Then what
Right.
happened?
Thereafter, there was calculation, my lord. Page 10. LA 30 of 93. But no payment is being made because the last line, the parties are directed to file objections to the calculation, if any, by 13/4/2011.
Then what happened?
Then, my lord, they have not carrying out this or not depositing this for last 14 years.
No. It is this matter is pending now in the
Civil Judge Junior Division Deogar.
So,
But no payment is there as per the order of this Honorable Court that they are to deposit before the trial court. They have not deposited or not
no,
given.
what is the present position of that proceeding in the trial court? We are not aware because you are giving the order sheet
My lord.
that is of the year 2011
My lord.
and we are in 2024.
That's
So what has happened in the meantime?
That's actually, my lord, that's not traceable, that file. As my client said,
So this court has already disposed of the
Yes.
matter and the matter is now before the trial court.
only
So
for
the
payment
trial court is to calculate the compensation.
and calculated,
It's all right, but
only payment. They have to make payments.
So,
Straight.
you
They are not depositing
you are
that
before
amount.
the right court. So take steps there and
My lord,
you again rush
Because-
to this court.
because parent of petitioner, the appellant died in the meantime, the father of the petitioner.
Whatever it may be, the
So there will be,
petition may be necessary. So whatever is there, so you have to proceed there.
they have to deposit, my lord. They are not depositing.
Alright, that is also the duty of the court to execute and proceed with that. Nothing to do with
The substitution and all that 14 years.
That's all right.
already passed.
Continue. All right.
You have
Yeah.
also submitted a representation before whom?
Before
It is
my
in
lord,
2012.
12.
So,
And commissioner come secretary and all that thing, but only payment to be made. That is my
right, so that matter is pending still sub judice in that before the sub judge Nayagar.
no, my lord, Deogar, my lord.
Which court it is now pending?
Civil judge,
Have you mentioned there in that in your writ petition?
my lord, that is the last order.
You have not mentioned anything about the status of that.
Present, my lord, that yes, I have no information also. They don't know anything. These are the children, and let them take a instruction. If it's land acquisition
No, we can
officer,
pass a blanket order on
my lord, land acquisition officer.
you have come for a certain
Yes,
relief.
yes, my lord.
You are not aware that what is the status of that particular case where this court has directed to pay the compensation. How can you get the relief?
My
You are annexing a order sheet of the year 2011. Why do you need to ask your client to verify to what is the status of that proceeding?
Get the certified copy of the latest order.
Yes.
You can know.
my lord.
What is the difficulty?
My lord, this file was not traceable. I have asked on.
Say that the file is not
Yes,
traceable.
yes,
Then
my lord, I'll bring that order.
This writ petition has been filed by the petitioners for a direction to the opposite parties, more particularly to opposite party number 2, Collector Deogar, to release the compensation amount passed in FA number 148 of 2001 with interest at the rate of 18% per annum within a stipulated period. It appears that the petitioner's predecessor approached this court, namely Paramananda Saw, approached this court in first appeal number 148 of 2001, which was disposed of in Lok Adalat as per order dated 17 and as per order dated 17/12/2010. The compensation was fixed at rupees 18,000 per acre, and the trial court was directed to calculate the compensation with a further direction that the total compensation amount calculated by the trial court to be deposited by the state before the trial court within 3 months from the date of such calculation. Land counsel for the petitioner drew our attention to Annexure 2, which is the order sheet of the Land and Civil Judge Senior Division, Deogar, in LA miscase number, whether it is 30 or 80. Is it 30 or 80?
30, my lord.
30 of 93.
3.
Of 93, which indicates that the calculation has been made way back on 5/4/2011, and the parties were directed to file objection to the calculation, if any, by 15/4/2011. The Land Council has not annexed the up-to-date order sheet, and we made a query to the Land Council about the status of LA miscase number 30 of 1993. She submitted that she has received the instruction that the file is missing. That is your instruction.
That is it.
File is missing. However, she may be given some further time to obtain specific instruction in that respect. Take care of your put up this matter in the week commencing from 17th September 2020. The other matter is same.
Same, my lord.
This matter should come along with same.
Item 3.
Please, Your Lordship. On behalf of my learned senior, prepare sought adjournment matter for submission of written note.
So we put a pertinent question on the last date, that is on 28/2024, that when a competent authority is in session over the matter and the petitioner has already availed that remedy, how this writ petition would be entertained. That is our specific query, and it appears that when you produce the order sheet of the Tahsildar Balangir in that mutation case, it indicated that Section 8A application under OLR Act, that is sub judice before the competent authority for conversion of the land from Bahal Mamuli to Gharbadi, because your claim of higher compensation can only be taken into account once this status, this land is converted from Bahal Mamuli to Gharbadi, and the competent authority is in session over the matter. So why are you taking time after time? the orders we have passed
That's a grant last time.
here.
Last chance.
Like next week, we are keeping it to no further adjournment. The Land Council for the petitioner seeks for an adjournment till next week. List this matter on 2nd of September 2024. It is made clear that no further adjournments are required here.
Item 4.
Item 4, my lord, and the brief has been transferred to me. I'm entering filing of Kalpana.
You want it to argue today or?
My lord, on 15/7, your lordship has called for instruction. 15/7/2024 on unnecessary 8 and 9.
On council for the status of the instruction regarding the development which have taken place after 15th one, so the date fixed. So on so for hearing persons who are alleged to have taken out the compensation amount not inside to the great reason and sold the land to the petition. And if they sell after the date of the section. So what instruction you have received as per the order dated 15/7/2021? Here, I do it tomorrow. Tomorrow. Yes. Just keep that gain amount mentioned tomorrow. Or $28. Yes.
Obligement.
Item 5.
May I please, your lordship? In case the petitioner challenged the Annex 6, your lordship, petitioner has been, while working as a messenger in the district judge of Fulpani, died due to cancer, your lordship. The petitioner applied as per the provisions under section 20 of the new rule, while awarding marks, 1 mark shortage. For that reason, his application has been rejected by the district judge.
No, you are challenging Annexure 6.
Yes, your lordship.
So come to that Annexure 6.
Yes, your lordship. Page 30. I am directed to intimate that your application dated so and so has been considered by the district judge come appointing authority for your appointment under Orissa Civil Service Rule 2020, found that you are ineligible appointment as per the provision section 2B of the Orissa Civil Service Rehabilitation Rule 2020. Sections.
No. What is the why it has been you have is there any analysis?
Yeah, evaluation points is there.
Fine. Where is that? This has come like this, or it is annexed with some.
No, it is the marks which has been awarded to the petitioner has not been provided.
No, it is found that you are ineligible for the appointment.
Yes, your lordship.
So, what are the reasons for which you have been held to be ineligible?
That is not there. It is only this document has been supplied.
How is it not there? It is in accordance with Rule 2020.
2020.
That the evaluation has been made by the district.
So, what is this particular provision 6.2b?
6.2b, your lordship.
Have you annexed that Rehabilitation Rules 2020 that relevant provision or quoted somewhere?
Section.
Have you not quoted it in your expedition?
No, I have not quoted.
Why? When a particular provision has been mentioned, that is the reason for which you are held to be ineligible, it is nonetheless required that you should quote that provision with you. It's a civil service rehabilitation assistant rules.
And in accordance with this rule, you find that the evaluation made by the district judge is not in conformity.
No, the result to the awarding of marks has not been communicated to the petitioner.
But where from you got this then?
It is only this document has.
That is not to you. It is set in the rule. How much mark is to be awarded against what point?
Only 1 mark. My child, elder child, is studying in class 8, and my younger child, a son, is studying in class 4. That mark is different. That is the only point where I am standing.
No, you are supposed to be given that mark. You have not been given.
No.
Is it that?
Yes, sir.
Where is that? Huh. Rules 28, 8 and no, law department.
16. This.
এটা রিক্রুটমেন্ট রুল দিয়ে আছে রিহ্যাবিলিটেশন রুল
এইটা টিকে
রিহ্যাবিলিটেশন 2020
সেটা দিচ্ছি সেটা
Why did you handed over that document to us? Rules? Is it relevant at all? ये ज्यादा बढ़ी दो. Pass on that.
Mode of appointment. So page 18 is the book. If the total allotted to the applicant in part 1 of the evaluation sheet is 44 or less.
6-2B.
Yes, your lords.
So 6-2 says on receipt of the application, the appointing authority shall verify the details furnished by the applicant, except information contained against serial number 6 to 8 of the application form, and determine the eligibility of the applicant by allotting points in the evaluation sheets given in Form D to these rules as given below. If the total points allotted to the applicant in part 1 of the evaluation sheet is 44 or less, the applicant shall automatically be ineligible for appointment under these rules. And in such case, part 2 of the evaluation sheet need not be filled up or as such. So this is the reason. So how do you challenge it? How do you challenge it?
My respective submission is my daughter is, your lordship, I have given the document which I have, that is the form. That is annexure 5 page 15, your lordship, Form A. My daughter, my unmarried daughter, that is Shriya Sudhiksha Pradhan, she is studying class 8. Inadvertently, I have in the form it has been mentioned in class 7. For that reason, 1 mark has been deducted.
Inadvertently means this annexure 5.
Annexure 5.
ମୁଁ ଲେଖିଲା ବେଳେ ଭୁଲ କରିଦେଇଥିଲି
କଣଟା ଭୁଲ କରିଛ?
ଯେ ଝିଅର ଯୋଉ ଆଡ୍ରେସ ଯୋଉ ଏଜୁକେଶନାଲ କ୍ୱାଲିଫିକେସନ ଟା ଝିଅର ଦବା କଥା ସେଇଟା ଫର୍ମ ଫିଲଅପ ବେଳେ ମୁଁ ଭୁଲ କରିଦେଇଥିଲି।
କୋଉଠି ସେଟା ଦବା?
At the time of application.
Application. At the time of application.
Which is the appropriate?
Where is that? Where have you mentioned? Or where you have?
Is absent. I have not given that column.
Then
annexure 5 page 15 ने सब देली केवल छुआर जो एडमिशन रो
माने no, because that you are so any that at least this much is clear that the total points which you have allotted is
less than
44.
44 or less.
44 by
44
again.
How do you know that you have got 44?
Because RTI I have got it.
Yes.
RTI
Under the RTI.
Recently I have got it by RTI.
Yes.
That I have awarded 44 marks.
Yes.
So for that reason my application has been rejected.
Yes. So is it not necessary on your part to annex this document?
I have not got recently I have got it.
Annex it.
Yes, I will amend the.
Yes, yes.
Give pass on that.
Yes. On first occasion it has not there.
It's all right. This petition has been filed by petitioner Srimati Sangeeta Nayak for quashing the order dated 15/4/2024 passed by the Land and District Judge Kanmar in rejecting the application for appointment under Rehabilitation Assistance Scheme under the provisions of Orissa Civil Services Rehabilitation Assistance Rules 2020 vide annexure 6. From the order, it appears that the petitioner was held to be ineligible for appointment as per provision under Rule 6(2)(b) of 2020 rules. I've been like the bracket with 2020. Section B reads as follows. 4% of 25. 6(2)(2) type कर देगा और P type कर देगा. 8 है cross मार देगा. तब तो भी cross कर देगा. So far, the land council for the petitioner submitted that recently he has on the basis of the RTA application dated 17/7/2024, he has been provided with the certified copy of the evaluation sheet in Form D relating to our application under 2020 scheme, which indicates that total mark is 44, but the total marks he received is
Points and total points.
Total points received is 44, and he intends to amend the rate for this petition by bringing the information received from the district court for Bani on record by filing an interim application. File
A week time.
put of this matter in the week commencing from 9th of September 2024. If any interim application is filed for
Item number 6.
6 minutes. I can look into the order dated 21/8/2024 minus
Yes,
that.
sir. All for the
The learner state council. Upon instruction in the may I flag C.
the instruction.
Minute.
Actually, which is irrelevant.
Kindly come to the second page, fourth line, fourth parameter.
as per lines, guidelines.
The land acquisition, plus 80% disbursement of the compensation amount, possession is handed over to ITCO, and afterwards, after transfer of the land in favor of Messrs. Nalco, possession is handed over to Messrs. Nalco on dated 25/1/2019. Copy of the possession certificate is enclosed and the C. However, to know the present status of the land regarding cutting of the tree, a local level inquiry has been conducted by RI Amin of this office. As per the report of the RI and Amin, nearly about 60 to 70 trees have been cut down by the project proponent for the development of the railway siding. The above works has been done by the then land acquisition officer as per the guidelines under Land Acquisition Act 1894 and guidelines of the government. So there is no irregularities found in the land acquisition proceeding. In such position, the land proceeding has been.
Yes,
not served any copy to me.
inspection file can be opened. Come to that. Why this keep this matter pending? Come to the second phase.
Yes, madam.
As for guidelines to Podpontu, this is the instruction received.
And it is this statement is needs matters examination by this honorable court, my lord. Annex of 4 series mechanism in my petition. I have given the document that with regard to notification under section in following the 2013 Act, my lord.
You have specifically stated in your interim application that on 30/7/2024, we have
Yes, sir.
mentioned in that
Yes,
opposition party number 6 and 7 removed oblique uprooted about 1200 teak trees
Yes,
from
ma'am.
the petitioner's land in spite of your protest.
Yes, ma'am.
This is the report which has been received. That there is nothing about that. Your total, it is a
No, no, no. That I have given the affidavit, my lord, and nothing wrong. The statement made by claimant.
when it goes to that disputed thing, how can we enter?
No, my lord, I have challenged the entire land acquisition proceeding for also. That my main prayer.
You have already, you see,
My lord,
as per
similar case.
guidelines of 80% disbursement of compensation has
No, my lord, there no notice, nothing to this petitioner regarding the.
taken. You are going to that.
My lord, it
taking
needs
some-
my lord thorough
If you-
examination, my lord, by the
Anything disputed, you go to civil suit.
No, my lord, my lord's mechanism in similar matters, my lord has already been issued notice, my lord. That my lord's mechanism in this notice.
So now the instruction has come and they have stated.
And the second page.
That instruction, my lord, beyond the
Yes, sir.
beyond the
As per guidelines of government in revenue and disbursement management department by letter so and so, the case was referred under 13(2) of the LA Act to the competent court, that is civil judge, senior division, Angul, by LA reference case number so and so, for adjudication of the matter as per the government provision of law. The awarded amount to the tune of rupees so and so was also deposited before the honorable court by challan number so and so, dated 10/10/2012, which was reflected in cash book and award register. Copy of the cash book and the award register is enclosed here for the Annex B. In the meantime, 3 years was passed for decision and this award amount was left, for which the honorable court deposited the amount in the account of the Accountant General Orissa and Bhubaneswar.
But that is no information regarding what my lord tried reading.
Just
That is-
take instruction from your client and counsel.
Yes, my lord, I have given the annex of course series.
Mr. Counsel, this instruction just now it has been handed over to you. If you want to go, please go, otherwise we'll dispose of the matter. If you want to take instruction from your client on the basis of this instruction,
Well, similar,
otherwise we'll dispose of the matter.
my lord, similar issues also been raised in earlier application. My lord, I had issued notice to the opposite parties, my lord's mechanism.
But here we have already received the instruction.
What of
We
the,
are providing an opportunity. Don't say that we have not provided.
And the money was already deposited.
It's just been handed over to you, and it is against you.
let
And
them
we are
go.
giving opportunity to you to take instruction from your client.
But
Still, then you are not acting.
But I'm saying, my lord, let them notice be issued to their.
Why notice it? We have already taken the instruction has already been obtained. Why notice will go back again?
That is on my IA, my lord, because they are removing the trees. And my main prayer is, my lord, something that is without any my lord's mechanism annexer 7 series. They are following the 2006 notification, which has already been.
We are disposing of this matter.
Pardon, my lord.
We are disposing of this matter.
My lord, I am to.
So it is no more a question regarding the disbursement of compensation. If that is so, this instruction is very clear that the money has been deposited with the LA. You did not receive the money. The money has been deposited with the Accountant General.
That is my case, my lord.
No, that cannot be your case.
Yes, my lord.
Obligation is already there. Amount of compensation has been awarded. If you want further award, redetermination of award, you can go. You cannot say that.
My annexer 7 series, my lord.
What is that?
Yes, my lord.
7
I'm
series is
pressing,
what?
my lord. I'm pressing. Annexer 7, page 50, my lord, can be read with at page 14. Page 14 is the notification under section 4.1. My lord, can turn to page 14. Page 14, these are the land for 19 acres land was certified for acquisition in Mauja Gorabanj.
Right.
At page 14. That has been for Kalinga Coal Mines Limited. And that has been abandoned. As because the coal mines was blackmail listed, thereafter the Malaysia annex, hide annex of 4 series, it reveals that no such acquisition was existing. Malaysia Mechanic turn to page 14, plot number 24 and 25. That has been notified there in
These things have been detailedly mentioned.
Malaysia kindly have a glance for it. I am saying,
Have you gone through this document?
no one.
What they have written?
No one.
Then
Let them to take instruction.
that is exactly why when you have not gone through the instruction, they have detailedly stated what has happened. And you are not prepared to go through this. You are just going on arguing. We are agreeable to grant you time. We are taking.
Other two connected read petitions are there, let it be listed along with
The as per the order dated 21/8/2024, the Learning Council for the state has written instruction from the land acquisition officer on board, which is dated 28/8/2024. And a copy of the same has been furnished to the Learning Council for the petitioners in today to seek some time to go through the same. Put up this matter. We are listing this matter next week. Pick up this matter on 2nd of September 2022.
matter. Similar matter was posted to 17/9 matter. Let all matters be come on 17/9. Matters are issued notice on the
By the
on my mouth.
council for the petitioners that similar matters like so and so on. Give the list are pending before this court in
That public is
put up
number
this
I have
matter.
given.
Please give a list of those cases
Which have been fixed to 17.
which has been fixed to 17th September 2020.
Only one case matter. I have
All
given
right, whatever that. Yes.
that
आप पूरा टिपिकिन दो ना आंधी हाँ ठीक है
WPC 19564.
बाबा उन्हें टिपिकिन दियों तो स्लीप रे काले भूलवा ले जियो.
Yes, Doctor. I have given the certified copy of the order of matters, which has been
Yes.
Item 7.
My lord, item 7 permitted to withdraw with a liberty to file better petition. Here, my lord, the provisional allotment is under challenge. Till yet, I have not received the impugned order on the right to information
for the petition. You are filing a memo?
Yes, ma'am.
Files a memo for withdrawal of the disposed of our yes.
My lord, item 8.
Item 8.
Yes. I may kindly permitted to withdraw with liberty to file better application.
Filing any memo? Please,
Because there are every page correction is required.
Yes.
So it is
आप बटे मेमोरी लिखी दियो तो withdraw करते हैं वाली बात सच्ची तो बताओ हम पूछ दियो.
with liberty.
जहाँ लिखा होता है ताज़े लिखी दियो तो disposed of our yes. Next.
Item 9.
Yeah.
The grievance of the petitioner is with regard to payment of compensation. In 2012 till date, he has been making representations before the authority. Authority is my lord collector.
Why you are seeking for compensation? What has happened?
Compensation, my lord, he has got a true well in the land, government land. So one got the payment.
Practice representation.
My lord, it is 24th April, next year 2, my lord, 2. Again.
Say, what is the date of that?
24th April 2024, my lord.
So 29th.
Not
29th or 24th?
that is 24.
BCBC 29th.
Let me see, my lord.
और seal मराई जी.
Aja.
Annexure 2.
Annexure
मैं
2.
आपको विश्वास
Annexure.
29 तारीख पर.
So kindly, lordships, within a time specific time.
3 months. 3 months from the date of production.
Aja.
Annexure 2 to be disposed of from the date of production of
29.
certified property.
Sorry.
And to them be communicated within 2 weeks of the taking petition. We have expressed no opinion on merits. Okay, yes, disposed of.
Item 10. Item 11.
The petition highly representation for enhancement of the compensation money. The Annex 10,
Where is your representation?
petitioner could directed to consider the representation.
Then what happened?
The Annex 10, the land acquisition officer dispose of the representations without mentioning any reason for enhancement. That NHI Act 3G5 minor, there is a provision for refer the arbitration, highly arbitration application before the collector from arbitrator for
Just
enhancement.
a minute. Which order you are challenging?
Annex 10 minor.
Annex 10 रे गुड़ाई order अच्छे.
The order dated 8/6
18/6 or
18/6 to
18/6/24
minor.
Page number
Last
कितने?
page 52 minor.
Just a minute. 18/6/2024. Yes.
Petitioners registrants register under the MSME sector. I pray for enhancement of the compensation regarding as a MSME
So
sector.
the reason which has been given,
Minor.
you just come to that page number 53.
53 minor.
53 of
Under the above
paragraph. It may be a
it
fact.
fact that the business of the petitioner is like to be affected due to the acquisition of land for the construction of NS16 with relation to the benefit of the employee and management of the restaurant. But its existence the origin of does not allow to consider the benefit of the employee's life to be affected due to acquisition of land. Under the above circumstances, since the award has been made for the land and assets thereon within the ambit of the law, this court is not inclined to consider the enhancement of compensation amount already been awarded on the representations of the petitioner made on ground that his employee and business shall suffer due to acquisition according to the representation. As per
What is
the
your submission?
as per the NHI Act 3G5 minor.
देखो.
If amounts
Just a minute.
minor.
PG5
minor.
If the amount determined,
If the amount determined by the competent authority under the subsection 1 or subsection 2 is not acceptable to either of the parties, the amount on the application by the either parties be determined by the arbitrator to be appointed by the central government. Here collector is the arbitrator as per the note.
So who has passed this order?
Land acquisition.
Yes.
is there from the side of the Indian government?
So what you meant to say that this matter should have been referred to
Arbitration.
what you say?
You should have filed an application for arbitration
Yes.
before the collector,
Hmm.
who has been declared an
As in not,
That's
it is not met.
So
Instead of filing that
Yes.
this application, he has stated that I have filed a representation before the land acquisition officer. That may be direction.
So he has not moved to the authority. You moved to the authority, has he denied?
Along with the claim.
Yes,
you move the competent authority because
for arbitration.
once you know that the collector is the competent authority,
Provision is there.
determine as to whether you are entitled to get some more compensation or not.
My lord, if,
This shows that you have not approved the
my lord, if he is not accepted by the either party,
Yes, yes. You are right.
maybe file arbitration if I have filed a grievance for enhancement of compensation.
But you are not accepting.
My lord.
You are not accepting that amount.
No.
So you move.
I will file.
You
I'll file appropriate
We are
application.
disposing of that if there is a provision,
My
you
lord.
have to move the order.
My lord.
Or the land and counsel for the petitioner and counsel for the Mr. Das, you are appealing for which opposite? For opposite party number 4 and 5. In this writ petition, the petitioner Relief Panda has prayed for set aside the order dated so and so passed by the opposite party number 5 with a further direction to the opposite party numbers 2 to 5 to consider the grievance of the petitioner for accurate compensation amount by calculating all loss of the petitioner, which is going to happen as the recorded property building constructed over the said land and so on. So the first paragraph. Earlier, the petitioner approached this court in WPC number
69/23, my lord.
which is that annexure? The order dated?
Order dated 9/1/2000.
No, annexure
36.
36, annexure 7.
Yes.
Approached this court earlier for the self and relief in WPC number 1. WPC number 1.
69.
69 of 2020, which was disposed of as per order dated 9/1/2023 with a further direction to the opposite party number 3 to consider the representation filed by the petitioner and to pass appropriate order in accordance with law. It appears that on the basis of such order passed by this court, the land acquisition officer dispose of the representation as per order dated 18/6/2024, wherein it was held that since the award has been passed, award has been made for the land and assets, they are within the ambit of the law. The court is not inclined to consider to enhance the compensation amount already awarded. The land counsel for the petitioner drew the attention of this court to section 3-G(5) of National Highways Act 1956, which reads as follows: quote the provision of National Highways Act. It submits that since competent authority is available, who is the collector, that is opposite party number
2, my lord.
2,
My lord.
to determine whether the petitioners would get the higher compensation or not. The petitioner may be permitted to approve the appropriate authority. Mr. Das, land counsel appearing for the opposite party number 4 and 5 has no objection to such submission, considering the submission made by the land counsel so and so. If petitioner approaches the opposite within a period of
1 week.
1 week from today, the file the application, the same shall be disposed of in accordance with law within a period of 3 months from the date of receipt of the application, and the result thereof shall be communicated to so and so within 2 weeks thereof. It is made clear that we have not expressed any opinion on the application which is to be filed by the petitioner for enhancement of the compensation amount accordingly. So which is basically filed. Yes.
Item 12.
11, 12 both.
All are same answer.
All are.
12 is regarding compensation amount is representation pending.
Annexure 3.
Page 49 minor. Representation dated 9/6/2020.
Which is the annexure?
3 minor.
3.
Dated 9/6/2020.
Okay. The annexure 3 is pending. It is to be disposed of and acquisition officer judgment.
Item 13.
Yeah, primary. Well, the case, my lord, land of this.
I have sought for instruction. I have sought for instruction from the opposite party, my lord.
Yeah.
NHA. 2 weeks time may be granted.
Mr. Das, Land Council appearing. You have not filed the. This is not required to file appearance memo, or you.
I have not filed. I'm listing Dokaratama.
Okay, you are to file that.
Yes, I have instruction to appear.
Okay. Mr. Das, Land Council submit that he has instruction to appear for which opposite parties?
1 and 2.
1 and 2.
Yes.
1 and 2, and we file the Wakalatnama by next week for Wakalatnama. Wakalatnama, and the matter will be taken up after 2 weeks in order to obtain instruction.
There are other 5 matters.
Yes, my lord. My lord, I have a list of the matters, my lord.
Give the list.
Yes.
Is this matter along with so and so indicating the name of Mr. Das in the cause list. It is to come on 17th. So
Yes. Obliged.
Item 14.
Please,
yeah.
Well, I have challenged annexure 10. Lordship, look at the order passed by the United DCS, Balangir, page 34. Well, I have seen that annexure.
Everybody, please read that.
Well, in view of Rule 8 of the Orissa District and Civil Courts Judicial Staff Services, method recruitment conditions of service to 2002, it is hereby ordered that say Anil Kumar Vaji, son of Franco, resident Franco, junior clerk of the Court of PO, exclusive special court under ST/SC POA Act, Balangir, attached to the Court of Civil Judge, Junior Division, JMFC Saitara, is discharged from service with effect from 16/12/2023 for his misconduct, keeping in view the interest of department and the public. For remaining in absence from 4/8/2023 to date, submitting resignation and removal by producing pathological reports without any government or recognized or registered medical practitioner's prescription. Friend was asked to join in service, writing letters to the other side, as well as to the JMFC Center to withdraw his resignation without physically turning to join it. Inform all concerned. Against this matter, the representation was filed with the decision in election 11, page 35. That is pending.
What do you want?
Well,
That is already disposed of.
that will not be disposed.
Vice versa things.
Pending. So no order has been received from the learned distributors.
No.
So you want the learned distributors to communicate the order on your representation.
Well, we will not pass any order on that representation. Having passed that order in the election 10, I think we have not considered that application. And if you also go to the rule, there is no question of appeal, there is no provision for appeal.
Right?
Because it's not a punishment order.
No, not yet. You have not yet been communicated.
Oh, yes,
Let it come. Dispose of.
This petition has been filed by the petitioner Anand Kumar Majhi, challenging the order dated 16/12/2023 passed by the Learned District Judge Balangir. That is order number 86 of 2023. In discharging him from his service with effect from 16/12/2023 for his misconduct, keeping in view the interest of the department and litigant public for remaining unauthorized absent from 4/8/2023 and submitting resignation on filimisy ground by producing pathological reports without any government or registered medical practitioner's prescription when was asked to join in service, and writing letters to the London District Judge as well as to the JMFC Sanitala to withdraw his resignation without physically turning up to join. The party and council submits that a representation has been filed before the London District Judge Balangir on 22/12/2023 for sympathetically considering this case and to revoke the disengagement order issued on 16/12/2023 and to accept his joining. However, he has received no response from the London District Judge. The Land Council submits that appropriate order may be passed to the London District Judge to consider the representation in accordance with law. The Land Council for the state has no objection to such prayer, considering the limited nature of grievance of the petitioner. We dispose of the petition that if any such representation would have Annexure 11 dated 22/12/2023 is still pending with the London District Judge Balangir, the same shall be disposed of within a period of 2 months from the date of production of the certified copy of the order before the London District Judge, and the result thereof shall be communicated to the petitioner within 2 weeks of the taking decision. It is made clear that we have not expressed any opinion on the merits of the representation submitted disposed of. Yes.
Item 15.
Please, Lordships. Under the present petitioners pray for a direction, my lords, to include them in the old Provident Fund rules and the pension rules, my lords. In Annexure 2, my lords, the opposite party number 1 had intimated all the district judges to furnish information related to appointment in regular government establishment, my lords. In Annexure 3, my lords, the opposite party number 3, the district judges have submitted the documents, my lord, but till date, no decision have been taken, my lords. Similar matters has been disposed of in submitting the judgments, my lords.
He will copy to the London State Council, let him verify whether it is a similar matter or not. Mr. Mishra, please go through it. You can see that it can be disposed of in the light of the observation that has been made.
Kindly refer to the order 4/9/1999. So later under Annex 6.
Page 2.
And the council for the state submits that in the case of Annex 6 has been received by the opposite party number 3. Same shall be considered and after due examination necessary action has been just been proposed rejected. But notes of later under Annexure 6 is here.
In that case, Annexure 6 is in the present case, Annexure 3, my lords. We have furnished the information before OP1, but no decision had been taken. That's why we request that within 2 months or within a stipulated period, the decision may be taken by the OP1, my lords.
OP1?
Yes, my lords.
Government of Orissa?
My lords.
It is now pending with Government of Orissa?
Yes, my lords.
So this letter has been written by the London District Judge
to the government.
Yes,
so that is that is pending with the government.
My lords.
So this letter is dated 17/6/2024.
So how do you expect?
If you have come so early, or you have not waited even. So everybody is waiting there to arrival of your, and they will immediately take. There is no other work for that.
And for
So this petition has been filed by the petitioners for a direction to the opposite party to include the petitioners under the old General Provident Fund Orissa Rules 1938 and the Orissa Civil Service Pension Rules 1992, and to give all the consequential financial and service benefits accrued out of the same to the petitioner within a stipulated period. The Learned Counsel for the petitioner submitted that on the basis of letter under Annexure 2, information was supplied to the Learned District Judge, and accordingly the Learned District Judge submitted the information related to the appointment related to the appointment in a regular government establishment during the period from 1/1/2005 to 17/9/2005, and the filed later dated 17/6/2024. However, the opposite parties number 1 and 2 have not taken any action thereof. Current council submits that order may be passed directing the opposite parties number 1 and 2 to consider the information supplied by the Learned District and Session Judge County and include the petitioners in sworn without expressing any opinion on the merits of the entitlement of the petitioner to get the benefits under sworn. We dispose of the petition, the direction to the state government, that is opposite parties number 1 and 2, take a decision on Annexure 3 within a period of 3 months from the date of production of the certified copy of this order. It made clear that we have not expressed any influence on the merits of the entitlement of the petition.
Item number 22 and 48 are similar.
Yes.
Item 22 and 48 similar.
48.
My lords.
22, 22 or 48?
22, this is similar to
14.
Item number
22 out of 48.
Item number 15, similar to item number 15. Well, vice number. How would it go?
48, my lords.
48.
My lord, item number 22, my lords.
Just a minute, similar to item number 15.
22 ରେ my lords ବିଳାସ ନାୟକ ଟା ଏନେ ଆଇ କେ ହବା କଥା ଏନେ ୱାଇ କେ
ବିଳାସ ଆଇଟମ ନମ୍ବର କେତେରେ 22 ରେ ଏନେ ଆଇ କେ ଦେଖି କଣ वकालतनामा कौन साइन କରିଛନ୍ତି
एने आई के
you want to correct that writ petition cause title ଅଛି ये You file that because it's online filing. The land counsel for the petitioner submits that inadvertently in the post title, the name of the petitioner has been mentioned as Bill Boishalini N-A-Y-A-K, in state of Boishalini N-A-I-K. And the same may be corrected. Let the land counsel for the petitioner file a corrected post title during course of the day, which will be accepted. केवल से ती correction without issue for yes. This is on addition. This is only for that particular item. Yes.
Item 16.
Wait, please, Your Lordship. My Lord, this is regarding compensation. So what has happened over here is the petitioners, along with other co-sharers of the petitioners, were in possession and had title over the land bearing plot number 293 by 430 of Kotak Sor Moja near Khannagar, my Lord. The cremation ground, my Lord, the half of which was taken over for the new bus terminal, Netaji bus terminal. What had happened here, my Lord, this land, 1.67 acres, was initially in the name of the petitioners and his co-sharers. But in the settlement, my Lord, this land went into the government khata, for which they had filed one RP case, which is at page 28, my Lord. Page 28. Page 28, it was disposed of in our favor. Your Lordship may kindly see the order at page 34. The Tahsildar will notice the parties and remeasure the area of the suit, HP number 293 or HAL plot number 293 by 430. He will correct the area map according to the lawful entitlement of the petitioner. Any excess position without entitlement should be ignored. The interest of any person not made party to the case cannot be adversely affected without proper notice. The ROR will be corrected within 4 months of receipt of this order. Well, this order was never carried out by the Tahsildar. I had represented to the collector and all. And what in the meantime happened, for the establishment of the new bus terminal, this land was entirely taken over by the government without any notice under land acquisition or any compensation.
Now unless that ROR is corrected,
yes, my Lord,
you cannot have any
claim
that you have not been noticed.
That is what, my Lord, I have filed before the collector.
No, it's all right. So your representation, which is dated, it is under Annexure 5 series.
Yes, my Lord.
So that has you have not received any communication.
No, my Lord, I haven't received any communication.
So unless that is corrected, or then you cannot get that.
My Lord, that is the pretext on which the government is not has not entirely initiated any land acquisition proceeding on that particular patch of land.
Yes, it's a matter to be adjudicated by the civil court then. Unless you have your status, how can you?
Yes, my Lord. My Lord.
Now first you have to establish your status because now it is in the government land.
Yes, my Lord. My whole difficulty is, my Lord, there is no single piece of paper from the government which says we are not paying you compensation because this is a government land. So if I go to the suit also, I may need that order from the authority. I may need that order from the
authority. Just dispose of the representation.
Annexure 7, Your Lordship, may kindly see is the representation. I have filed one miss case before the collector, land acquisition collector, cut up, my Lord.
So, but by that you cannot get the result.
Let him dispose of one. At least I can go to suitor and
asking for initiation of the land acquisition proceeding in respect of scheduled properties.
Yes, my Lord.
That proceeding is initiated,
my Lord,
how you are going to get the relief?
My Lord, as far as the Tahsildar order is concerned, my Lord, that is for correction of the ROR.
Yes.
It has admitted that I am in possession. That is my property. It has been wrongly recorded, my Lord.
In any case, you need to get a declaration. Without that, how can you?
Yes, my Lord. I admit, my Lord. But they have to answer to it that why they have not initiated the land acquisition.
And the collector makes a declaration. That is the main thing.
No. I am not seeking a declaration from the collector, my Lord.
Unless the declaration is made, you cannot get that relief.
Let the collector.
You want just Annexure 7 to be disposed of.
Yes, my Lord. Let them say that this is the reason why they have not initiated.
But, this petition has been filed by the petitioners. Challenging non-disbursement of the compensation amount in respect of so and so you click there. The Land Council for the petitioner submits that this case number 1 of 2021, which arises out of RRP number 1010 of 1995, has been filed by the petitioners along with other co-sharers before the collector LA collector Cutter, and the same is sub judice, and direction may be issued to the also to dispose of at an earliest. Land Council for the state has no serious objection to such prayer, considering the limited nature of the wants of the petitioner will dispose of the petition, that if in this case the annexure 7 is still sub judice, this particular collector so and so is opposite party number 3. Yes, madam. Shall dispose of the same at an earliest, preferably within a 6 months. The current state opposite party within a period of 6 months from the date of production of the certified copy of the order, and communicate the result thereof to the sworn. So it is made clear that we have not expressed any opinion on the merits of the case which has been instituted under Annexure 7.
The opportunity of hearing may be given.
That is obviously you get in the miss case file करते हैं अपन माने निश्चय अपन to ये करिए by providing the opportunity to the respective parties for them. Yes.
Item 17.
19. Covered what? 17, 18, 19.
17, 18, 19.
19 as per annexure. 17, 18, 19. As per annexure 4. 30.
Just a minute. 30 disposal. How would it be? 40 disposal. 43.
Annexure 4
Although 12, 30 and 43. What are
40 to 43.
40 to 43 and page number 4 list cause list out of item number 30 in page number 3 and this 17, 18, 19 of page number 2. These are the matters disposed of. Yes.
Item 20.
Please, Lordship. Here I have challenged the acquisition of land under the Petroleum and Mineral Pipeline Acquisition of Right and User Land Act 1962, where the land of the petitioner proposed to be used for the line pipe, gas pipeline. I have annexed the Act, my lord, at annexure 2 of the petition, page 14.
When that notification was made?
Notification, it was first notice was served under annexure 3 at page 23 and 23/5/2022.
Okay, you have filed your objection.
Yes, my lord. Next.
Then what happened?
They have called me for a personal hearing. Thereafter, my lord, they kept silent.
No, whether this matter is still sub judice or?
My lord, I have asked them, I have running to their office for the.
No, who is supposed to appear for these opposite parties here before this court? Union of India.
Union of India is one and
is there. And
yes,
in India,
1 and 2 both. Yes.
1 and 2, Mr. Padi, you will appear.
Yes, we are appearing both. GAL and.
So, His prayer is now that maybe to dispose of the he has already submitted a representation by Annexure 4
And
and
under Annexure 5, they have fixed a
the
date.
date was fixed under Annexure.
But my lord, here I have seen that Annexure 4, page 25,
Yes.
they have addressed to the project officer, but he is not a party to this. He is like the managing director.
Why have you not made it? The representation is pending before the
But
project.
thereafter they have asked me, well, thereafter they have asked me for personal hearing under Annexure 5 after submission.
That is by before the competent authority.
No, this competent authority is a different authority. He is not managing director, not dependent by the competent authority.
But he is issuing the notice.
Competent authority
Competent authority means this competent appointed under this special statute, my lord. Officer
Competent authority
Under the statute.
That they are in the page 15. At page 15, in the definition.
No, Mr. Padi is submitting that we are to issue a direction to a particular authority to dispose of your representation.
That is the
so he should be made a party in this writ petition. Who is that opposite party?
That opposite party is, my lord, OP number 2.
No, my lord.
No.
Better it is comfortable to my lord friend that they made a party to the competent authority, then it is better.
And please see your Annexure 5. He's
managing director, KL Bhavan, this is managing director.
But you see Annexure 5, it is with somebody else.
So it is the competent authority. They said it is a competing authority.
Competent authority under 2A.
2A.
Definition 2A.
2A. But it is a company. Competent authority cannot be a company, my lord. Because 2A said that a person duly notified by the central government.
Yes, basically the gazette notification, the particular authority was appointed, the competent authority for adjudicate the issue.
Yes.
Not mean that the competent authority is managing director. Not like this. So it's better is implement the competent authority party, then it is better to.
That is exactly.
I will file an application.
Amend that application. Just add that opposite party so that appropriate order can be filed. Let it be there.
Yes.
Why are you not bringing that IA tomorrow?
Tomorrow I will bring the IA.
Okay. You are keeping to tomorrow. Yes.
Let's keep it tomorrow, man.
Tomorrow. You just file IA here and give a copy to you, and the rest of the thing will be done.
Appearance will be noted, man.
Okay.
Item 21.
Item 21, may I please your lordship. The petition has a structure house under plot number 205 or khata number 28, village Banki Bahal, my lord. That is acquired by the MCL authority, my lord. To that effect, my lord, the petitioner, the approach is grievance in the civil case number 325.
What is the civil case number so and so? Where it is pending?
My lord, it is pending for the claim commission, Honorable Claim Commission, Bhubaneswar, my lord. And the last notice received by the petitioner is 8/12/2021. Thereafter, no any substantial progress.
It is still sub judice according to
yes, my lord.
You want a direction for disposal, early disposal of that proceeding?
Again.
Writ petition number so and so. This writ petition has been filed by the petitioner Rajesh Kumar Patel with a prayer for a direction to the opposite party number 3 for early disposal of civil case number 325 of 2017. The Learning Council for the petitioner submits that way back in 2021, we received a notice from the opposite party number 3 in this case, and thereafter under Annexure 2 series, and thereafter he has not received any communication.
Any notice, though it is mandatory to be individual notice on every
community concerned authority. And since 7 years have already passed in the meantime, appropriate direction be issued to the opposite party number 3 to expedite the disposal of the case. The land council for the you are appearing for this collector, na Sundar? Land council for the state is present for opposite party number 1. Considering the limited nature of the arts of the petitioner, and since civil case number since the case is sub judice before the opposite party number 3 for more than 7 years, it is directed that the opposite party number 4 will do the needful to expedite the proceeding and conclude the same within a period of 6 months from the date of production of the certified copy.
Highly obliging.
Order. It is made clear that we have not expressed any opinion on the merits of the proceeding. Yes, next.
Item 23.
Mallet, useful grievance of the petitioner is that mallet. But in bank mallet of the
Petition is annexure 3.
Yes, madam.
For OTS.
Yes, madam. I'm ready to pay my
Who is for the bank?
Some part. Ponda, I don't know full name, but Ponda is there.
And 13.4 you are challenging. It is your go to. You are required to go to.
I am ready to pay my let them consider my independence by the necessary matter. I will pay. I am not going to challenge anything. I make my land.
Notice has already been this.
They are not listening to me, matter.
The same relief can be you can get it in the before the DRT.
Your lordship can direct me, matter. I will pay. I will ready to pay, matter.
When
in spite of
entertaining this matter has been prohibited, or there is a ruling not only of this court of this.
I'm not challenging anything, matter. I am ready to pay. Your lordship simply direct to the consular and I will pay, matter. That's all. I have nothing to challenge here, matter. I have not come here to challenge anything, matter. Because I have to make my land free. Only I am dependent on agriculture, matter.
Any kind of order passed in this petition, maybe a representation disposal.
No, not disposal, matter. Not disposal.
File this one, so alternative remedy available disposal. Yes, upload. Yes, next.
Item 24.
May I present? The petitioner prays for release of the benefit under the RL policy 2006 matter. Consequence of benefit and the appropriate authorities of number 3 matter, the land acquisition officer. And he has made a grievance, on annexure 4 matter as page 31. That is pending for adjudication.
Annexure 4 to be disposed of within 3 months from the date. Yes.
Item 24.
The Lordship may kindly grant a short passover.
What is your share in this petition?
The Lordship, in this, the petitioner has challenged the Annexure 9, in which the opposite party number 4 has initiated a suo motu resumption proceeding against the petitioner.
Which order is there?
Annexure 9, page 41.
Page 41.
The Lordship may kindly see first paragraph towards the end. However, as per R.I. Chandaka.
Which 41? That is order dated 2/7/24.
Yes, Your Lordship.
Yeah.
First paragraph towards the end. However, as per R.I.
First paragraph. That paragraph starts with this case is taken up to
Yes, Your Lordship, towards the end. However, as per R.I. Chandaka.
Yes,
However, as per R.I. Chandaka report during mutation proceeding, it is reported that the suit land is used for non-agriculture purpose. Accordingly, as per the power conferred under Section 3B of the Odisha Government Land Settlement Act 1962, the proceeding for resumption of suit land has been initiated by Miss Case number 2812 of 2024. Lordship may kindly take page 42.
Yes.
Page 42 towards the end, wherein the petitioner Towards the end, wherein the petitioner contending that the suit land is not in DLC list as per the letter number 21864F 19/2024 Bhubaneswar dated 4/4/2024 issued by Office of the DFO Chandaka. The suit land is not in the DLC list and is not coming under Jungle Kisam, but it is coming under Sarat 3 of Sthitivan status. However, it is pertinent to mention that as per letter number 22774F dated 8/4/2024 issued by DFO Chandaka, the Sabik plot number 1958 of Moja Andharwa is in DLC list. Accordingly, all the byplot from the same Sabik plot, including the suit Hal plot number 4295 pertinent to Sabik byplot, is also of Kisam Jungle. And the second contention of the petitioner that the suit land is used for agriculture purpose since long is not supported by any evidence. Lordship, same page towards last paragraph may be seen.
Read out that entire paragraph. From the continue.
Okay. On field verification report and the geotag photo dated 30/3/2024 attached in case record, it is revealed that the suit land there is a Moram Road land lying followed with few recently planted saplings of papaya trees and is bounded by compound wall not used for agriculture purpose. As per the lease term, the west land is given on lease to the landless agriculture labor for agriculture purpose, but same is not put to agriculture use by the petitioner. Rather, the Moram Road, constructed in between make it unfit for agriculture, and it seems the petitioner planted some papaya saplings just after initiation of the mutation proceeding with ulterior motive to grab the valuable government land for agriculture purpose. From the above deliberation, it is evident that the suit land of extent A 1.0 of plot number 4295 khata number 287307 pertains to Sabik plot number 1958 Sabik khata number 805 Moja Andharwa given on lease to 1 Kumar Swai by WL case number 1278/1974 for agriculture purpose. However, same has been put for non-agriculture use by the present recorded tenant Tilotama Bahinipati. Hence, as per power conferred under Section 3B of the OGLS Act, above suit land recorded in ROR Khata number 287307 of Moja Andharwa is ordered for resumption to the original government Khata number 2873 of Moja Andharwa.
You have got that 3B.
Yes, Your Lordship.
Is present.
3B. Resumption of land and imposition of penalty. Any officer authorized under Clause E of Section 3 may resume any land settled by him if he has reasons to believe that the person with whom the land was settled has used it for any purpose other than that for which it was settled, or the person other than the homesteadless person or landless agricultural laborer has not used the land for a period exceeding 3 years from the date of such settlement and may impose a penalty of an amount not exceeding 1,000 rupees on such person. Provided that no order under this section shall be passed without giving such person a reasonable opportunity of being heard in the matter. Provided further that any land settled prior to the commencement of the Odisha Government Land Settlement Amendment Act 2013, if not used within a period of 3 years from the date of such commencement, the authorized officer shall resume such land.
So now you come to Section 7. Yes. There is a provision of office.
Your Lordship, this is the fourth round of litigation that the petitioner has come.
Maybe fourth round. Once the order is passed under 3B, you are challenging the same. The competent authority is the appellate court, not this court.
Your Lordship, the petitioner had come in the writ appeal. Thereafter,
this particular order was passed recently on 2/7/24.
Yes, Your Lordship.
Have you approached the appellate authority?
No, Your Lordship, because in the contempt first, the order was that the RO.
Whatever has been passed, it is passed. Now this phrase order has been passed on 2/7/2024 and it is a appealable order under section 7 of the OGLS Act. So why have you come to this court? We are putting a pertinent question to you.
Your Lordship, in this the
If you are not
resumption.
prepared, prepare yourself. Come tomorrow.
Your Lordship, may kindly just see Annexure 5. The RI report that was been given by the revenue.
Different. You are going on a mail. We are asking you a plain and simple question. The order which is impugned in this case is an appealable order, and section 7 also makes it very clear. So instead of that, why without approaching the appellate authority, you have filed a writ petition, and writ petition proceeding cannot be entertained unless, of course, exceptional circumstances if the alternative remedy is available. We are asking him to prepare this case tomorrow. She will address tomorrow. Okay, you assist him in the chambers, and she will. Why you have not approached the appellate authority, right? That answer will tomorrow. Rest of the matter.
Beg your pardon, my lord, item number 131 that has been listed actually in a similar matter at a batch case. Since my lord Justice Das will not hear this and the order has been passed in the same batch matter.
131.
131. Jagannath Mahanti versus State of Odisha and others. Similar batch matter. Again. Relating to the junior class of Jagat Singhpur.
So I was in the appellate committee.
My lord, sir, the last order actually is arising out of the disciplinary proceeding of District Rabi Mishra. Where
No, I was not there.
my lord, the appellate committee.
That is what.
Yes.
So in the appellate committee, right? Yes. If that is so, then
My lord.
if I have passed an order in the appellate committee, I can.
My lord, item number 131.
My lord, item number 34, that is also
131 to
31.
item 54. Well, that is also similar track to that annexer item 6, my lord. Item 6, well, since notice has already been issued in the earlier application, my lord, in this case, my lord, direct to until written instruction in the matter, my lord, may be direct. So,
79 with so item number 6.
well, and in this case, written instruction also.
Therefore, tomorrow, yes, you can take. Therefore, tomorrow it can.
Let's say item 89, your lordship had directed the state to get instruction whether the petitioner getting salary. So that 4th PM matter, your lordship. Your lordship had directed the opposite party to get instruction whether they are being paid the salary or not. It was listed earlier in the week in the weekly list, but it could not reach. I humbly pray your lordship listed in the supplementary list in any day of this week.
We will start from item number 26 onward. We will proceed. There are 2 more days. Why are you expecting that the matter will not?
It's 89, item 89.
All right, it will be.
Item 10. Tomorrow. Item 10 has been passed on.
By pattern last half matter item number 53 million. Tomorrow it will become infectious.
Which matter?
First half matter item 53. That kindly taken up.
No, we'll see tomorrow. Surface and matter.
Well,
Yes, next.
Weekly list item number 25.
Yes. You have received a copy?
Yes,
We produce this man.
yes, sir.
That IAC, Colliery Police Station, produce this Gonia Bagaria. Lepon. In pursuance of the order dated 22/8/2024. This should be passed in the interim application. Right? Mr. Dhanardhan Sethi, Advocate Clerks, appears in person in court today. Mr. Nityanand Panda, Advocate, has filed an affidavit. in terms of the order dated so and so, wherein it is mentioned as follows, put paragraph number 4 in entirety. Copy of the affidavit has been served on the land council for the state. Let inspector in charge of Colliery Police Station produce Gonia Gargarai before this court on 3rd of September 2024 at 2 p.m. Mr. Nityananda Panda, advocate, and Mr. Dhanardhan Sethi, advocate's law, is again present in person on that day. This affidavit is taken on record for them. Yes. Three copy of the order.
Item 6.
Item 6. 302 matter. No, 302 case no. Oh, 302. So hard admit for the trial court reports are engaged. We have free a copy of the judgment and 2 days order. We handed over to the land council for this case. And it needs to be intimated the asylum.
Item 7.
Wait, please, Your Lordship.
So,
Your Lordship, in the present appeal, Your Lordship, on the last occasion, Your Lordship had been pleased to call for the custody certificate, Your Lordship.
It was 16 years to 16 years. 945 days. 5,945 hours, 16 years. 302 of us, it's matter. Single model.
Your Lordship?
Single model.
Yes, Your Lordship.
No antecedents. No, I have really thought. In pursuance of the order dated 5/8/2024 And the learning council for the state has produced a written instruction received the custody certificate, which indicates that the physician has shared custody for more than 16 years. 16 years, 2 months. 16 years, 2 months. He has also produced written instruction received from the IAC, Baria Police Station, Keonjhar, which indicates that there is no criminal antecedent against the petition. The instructions, instruction within instruction as well as the custody certificate are taken on the since in spite of preparation of paperwork, the matter has not been taken up for the hearing and further taken into account the fit of detention, the petitioner in judicial custody. We are trying to release the petitioner from the and that the petitioner is now around 67 years. 67 years. We are inclined to put in the petitioner.
What's your place to touch?
This was booking.
The book is very good.
This will be very difficult.
Item number 8.
The appellant who has been apprehended on 18/9/2008. It can be borne out from the judgment, my lord. And one injury.
Wait.
18/9/2008.
18/9/2008.
15 years, near about 11.
This court has not granted you bail.
No.
So whether you are on bail?
No, my lord. Sir, he has never preferred any application for bail. I have gotten it.
No, order से final form कर देता हूँ. ठीक है, final form दे. या मैं होता हूँ बाकी साहू. और ना सुनिए जरा ठीक. बाकी order से चलते. Produced in custody. Produced in custody. Single murder.
Single murder. One injury. That is phase 5 of such. One external injury, that is a stab wound due to quarrel.
Stab wound on the left side face.
Just below the
Or the learning council for the petition learning council for the state. Considering the submission made by the land council for the petitioner that the petitioner is in judicial custody for since 18/9/2008 and he has neither been released on bail during trial nor he has been granted bail during pendency of the appeal. And paperwork is yet to be prepared and therefore there is no chance of early hearing of the appeal. And after hearing the land council for the state and going to the impugned judgment, we are inclined to release the petitioner on bail allow.
Paperwork to prepare when they
either paperwork for preparation of the paperwork may be expedited. अच्छा ये hard withdrawn is the possibility. I said the name of Sunita Vishwas shall not be printed in the cause which stands for. She was appointed by the
Item 9.
Number 9. One under certificate naturally by council law. Next. Foreign here, under Polani, instruction they are performing. Non appears for the appellant. The petitioner was directed to be released on interim bail for 3 months as per order dated 15/5/2024, and the Land Council for the appellant was asked to produce the surrender certificate of the appellant. No surrender certificate has been filed. Let instruction be obtained from the Land and Trial Court as to whether the petitioner has availed the interim bail as per the order dated so and so, and if so, whether he surrendered at right time, and if not, whether any coercive steps have been taken for his arrest. Order be communicated by the Register Judicial to the Land and Trial Court email to be obtained, and the matter be explained with commencing from 9 September 2020. That will be put the date the delivery is not that is going to. We will check this. Okay.
Item 10.
Wait, please, Your Lordship.
And the certificate of plan number 1 not filed.
Your Lordship, we have filed that on the 15/5/2024. We have receipt of the same, Your Lordship.
ठीक है जो लगी है ये अंतिम में और चीज 15/5
2024. By receipt.
that he surrendered on 8/1/24.
Yes, Your Lordship.
Huh?
Yes, Your Lordship.
When
Yes.
he was directed to be released on
Your Lordship, he was directed to be released on bail by order dated number 223 of 2017.
25/9/2020.
Yes, Your Lordship.
This surrender certificate is of the appellant number 1.
Yes, sir.
Corunakar Malli.
Malli.
Right. Surrender certificate class F available on record indicates that appellant number 1 has already surrendered on 8/1/2024 and taken into judicial custody. Ethical judgment. Yes, next.
Item 11.
So you have filed your Binama.
Binama filed.
All right. This is item number 11. Period the prisoner's petition at Flag C for engagement of Ramesh Chandra Maharana as this counsel. Mr. Maharana and his associates have filed Vinama, which is accepted. The name of Mr. Animesh Mahanti shall not be reflected in the positive transfer. Correct.
My Lord, in this case, Your Lordship, please to allow granted interim bail for a period of 4 months. And the date of surrender, my Lord, 6th September.
Okay, you just thereafter the matter will come and he'll file the surrender certificate. It will come because the period is not over.
Yes.
Yes, next.
Item 12.
May I please, Your Lordship? My Lord, the appellant faced trial under section 498/302 and the 492.
What is the custody certificate? What period you have remaining custody? Actually, 3 months. 13 years. 13 years, 3 months. Offense kano?
302.
Single murder.
Single murder. 498/302.
Oh, wife.
Wife. The acquitted under 498 is acquitted. Only 302 is
498 acquitted.
My Lord.
302.
My Lord. No eyewitness there. Only the
strangulation na kono?
ଗୋଟେ କାଠରେ ବାଡେଇକି ମାରିଲା ବୋଲି
interim ଦିଆହେଇଥିଲା ଆଗରୁ? are the land council for the petition, land council for the state. The land council for the state has produced the custody certificate, which shows senior superintendent Circle Jail Baripura, 13 years, 3 months. Same is taken on that. After hearing the land council for the separate parties and going through the adjustment, while not intending to release the petitioner on bail on merit, but taking into account the period of detention and judicial custody. And since paper has not been prepared and keeping in view the related case, 3 months bail granted. And finally, the certificate and instruction to be obtained about its conduct. Yes, next.
Item 13.
My lord, on behalf of Mr. Ellen Patel, may I kindly pass over this matter to tomorrow, my lord.
Tomorrow. 2020. Okay.
Item 14.
Wait, please, Your Lordship. My Lord, item 14, Your Lordship, I am in VC, my Lord.
You are appearing to whom?
I am assessed. My Lord. In this case, Your Lordship, by order dated 13/5/2024, in IA number 600/2020.
Oh, where is the surrender certificate?
My Lord, I have surrendered on 24th of August within the time allowed by this Honorable Court.
Why are you not producing that surrender certificate?
My Lord, I'll produce it within a week, my Lord. I am filing an IF today mentioning that I have surrendered and my bail may be considered.
No, that we have to see that surrender certificate.
I'll file it.
You are don't file it. Why are you not filing it?
Yes.
Mr. Mishra and Council appearing to virtual note submits that he has received instruction that the appellant, after availing the interim bail period, has surrendered on 24th
August, 24th August, this Saturday, 24th August
2024, and he may be granted some time to produce the surrender certificate. Input of this matter will be commencing from 9th September 2024. Yes.
Okay.
Item 15.
The last occasion, my lord, call for the written instruction regarding the death of the appellant.
Is there committed suicide? The land council for the state has produced written instruction, a receipt form, whether it is IIC or OIC. OIC, Mohul DA Police Station, dated 25/8/2024, in which it is mentioned that the petitioner is dead. The appellant is dead. Appellant is dead. In view of section 394 CRPC, this appears for disposal. Since no legal language does it. The date that it was 9/8/2008.
Item 16.
That's not disposed of. Yes, item.
Your Lordship directed to instruction.
No. First of all, the death of appellant number 8, that is one thing. But we have not received the surrender certificate of appellant number 3 and 5.
I have not appeared.
So who is appearing for 3 and 5?
Naik.
Huh?
3 and 5 appear Biswajit Naik.
Biswajit Naik is appearing.
My lord.
My lord, the surrender certificate I am submitting, my lord.
3 and 5.
Yes, ma'am.
All right. Mr. Naik files the surrender certificate of appellant number 3 and 5, which is taken on dead ball. So there was a submission made that appellant 8 is dead.
Letter to the regarding the death of appellant number 8 is residing at Jharkhand.
Surrender.
8 of date of the 11th. Surrender certificate or so
is another statement type.
The Land and Council for the state submits that instruction has already been sought for to ascertain the date of appellant number 8 to June 9, and some more time may be granted for such purpose. Is this matter? Yes.
Item 17.
Please, Your Lordship. On behalf of H.N. Mahapatra, I seek some time, my lord.
State to produce the surrender certificate, to produce surrender certificate kodala.
I have no instruction regarding that, but
Instruction surrender korichi na nahi. Bail jayitla na. 16/5/2026 रे 3 मास jayitla. You have no instruction. All right, you put it down. The petition of the appellant was appellant number 1 for example, Manas Kumar Mahapatra was directed to be released on bail, interim bail, for a period of 3 months as per order dated 16/5/2024 in IN number 2017 of 2016. And an order was passed that the Land and Council for the appellant shall produce the surrender certificate of the appellant. Surrender certificate of the appellant has not been produced. The Land Council for the appellant submits that he has no instruction in the matter.
So my seniors.
Yes.
Interim order was granted for 3 months. Granted. Recently, he was released on bail 15 days before.
So you have not availed it immediately?
No. Because for communication of the certificate copy, there is time.
It's all right. The Mahapatra and Council for the appellant submits that recently the petitioner has availed the interim bail period, and therefore the 3 months period has not yet elapsed, and he will file the surrender certificate at appropriate time. Yes.
Item 18.
My lord. I am submitting the death sheet and written notification in IN number 5/5/2020 praying for bail for the appellant number 2. Appellant number 1 is the father. Death sheet and written note of submission for appellant number 2. Appellant number was in jail custody, died on copy soft, no soft. Appellant is in jail custody for a period of
appellant number 2. What is the name of the appellant number 2?
Pitambar Behra alias Tasodu.
So what is the period of detention?
11 years 4 months, starting from 26/4/2013 to till date.
It represents page फाइल की से ये डिफरेंट एटा जोटा फाइल आज कोचन डेट चार्ट मिस्टर त्रिपाठी
यस मैम
डेट चार्ट से फाइल
हां
ये पेज नंबर 4 को पढ़े सम पेज नंबर 4 इलेक्शन थी 11 years 4 months बोले आपण पाई आछन कस्टडी सर्टिफिकेट नहीं आसन जेरो हु जेल अछि
सर्कल जेल बहरमपुर
सर्कल जेल बहरमपुर The Land Council for the petitioner has filed a date chart and written note of submission, wherein it is indicated that the appellant number 2, December Beher RBS, Dasudu, D, is in judicial custody for 4 months. The written date chart is taken on record. The Land Council for the state has received a copy of the date chart and seeks some time to produce the custody certificate, so also to obtain instruction regarding criminal antecedent, if any, against the appellant number 2. Put of this matter in the commencing from not filed.
The appellant is surrendered on 28 2024.
The Land Council for the appellant filed the surrender certificate of the appellant, which was taken on record. Yes, next.
Item 21.
My pleasure. But here, madam, earlier the petitioner has sole appellant convicted on section 304B. His bail application rejected by your lordship on 14/2/2020. While rejecting the bail application, your lordship was pleased to grant liberty to the petitioner to file to renew his prayer for bail after 1 year. That was last sentence.
Yes, we have seen it.
Yes, but because of the COVID matter, there was we lost contact. Now I filed an application for bail, but on noting I find noting of the list that Mr. Arijit Mishra has filed an application for bail in the year 21, with after obtaining consent from us, my lord. I have verified the records today from Bhogla. I find that none of the recorded on record counsels have given consent to Mr. Arijit Mishra.
That means Bhinama indicates that consent has been given.
Yes, but that consent is that signature giving consent do not belong to any of the counsel, neither mine nor R.N. Mishra nor Sahoo. And S.K.Sahoo is dead in the meantime.
It's all right. So you want to place this matter?
Yes, ma'am. Yes.
Obviously, you IN number 1664 of 24.
Ma'am.
Okay. Our Mr. H.M. Land Counsel for the petitioner. We does not want to place this IN number 464 of 2021, which is disposed of. Mr. Hall submits that though Bhinama has been filed by Mr. Arijit Mishra and Counsel and his associates, and in that Bhinama has not been taken from either from him or from his associates. In view of the submission made by Mr. Dhar, the Bhinama the name of Mr. Mishra and the associates are not be reflected in the cause list. So, what is the period now you are in custody?
16, exact date. I may not be able to indicate.
You get that surrender certificate?
Custody. He is in custody.
No.
Custody certificate.
No, he was not allowed.
He is in jail.
Custody certificate. So let him bring that custody certificate. What is the total period you have remained? IN number so and so. Mr. Dhar and Counsel submit that the earlier bail application of the petitioner in IN number so and so was rejected as per order dated 14/2020. Our liberty was granted to the petitioner to renew the prayer for bail after expiry of 1 year. And here the instruction that the petitioner has remained in custody for more than 8 years. Land Counsel for the state took some time to fill the city coordinator.
जोड़ा सब जल लेते हो
additional session judge चंपू of the flying judge.
अच्छा
So वकालतनामा
वकालतनामा
और जेल की
सेटा टेस्ट होगा that's what सेटा
From the LCR it will be available at since oil is in
କିଛି ନଥିବ ଏବେ ଯୋଉ ଭି ନାମା ଫାଇଲ ହେଇଛି ସେଇଥିରୁ ଜଣା ପଡିବ କୋଉ ଜେଲର
21 ସେଟା ଫାଇଲ କରିଛି
ଏଟା କେଉଁ ଜେଲ ଅଛି ସବ ଆସିଷ୍ଟାଣ୍ଟ ଜେଲ ଡିଷ୍ଟ୍ରିକ୍ଟ ଜେଲ କେଉଁ ଜେଲ ଡିଷ୍ଟ୍ରିକ୍ଟ ଜେଲ କେଉଁ ଜେଲ Next.
Item 22.
It is to be listed on 9th. Huh?
Wait, please, my lord. Item 22, I am appearing virtually, my lord.
Yes.
My lord, herein the IA has been filed for bail of appellant number 3, my lords.
Yes.
My lords, there are total 6 appellants herein, my lord, wherein from appellant 1 to 5, they all belong to one family, and appellant number 6 is one of the co-villagers. Now, the my lords may see page 60, which is the relevant portion of the sentencing part.
Appellant number 3, just a minute, later. This is filed only for appellant number 3.
Only appellant 3, my lords.
What is his name? Udayanath Naik.
Naik.
You have mentioned his age to be 71 years?
Yes, my lords.
Okay. What is the age as per the judgment?
My lords, as per the judgment.
Udayanath 71 years. Okay.
Yes, my lord.
Right. So,
he has been dying, my lords, he has been suffering from various ailments, for which he was taken into taken to the hospital by the jail authorities, and at present he has again been discharged and is in custody, my lords. On medical.
No, what you wanted to show us from the judgment?
The period of the sentence which has been imposed on the appellants.
That is at page
68, my lords.
68.
Yes, my lords. Hence, I sentence all the convicts to undergo imprisonment for life and to pay a fine of rupees 20,000, each in default to undergo RI for 1 year, each of the offence under section 302 by 149 IPC. The convicts have also been found guilty under section 324, 307, 149 IPC for commission of attempt of murder of injured Bonchanidhi. Hence, I sentence all the convicts to undergo imprisonment for life and to pay a fine of rupees 20,000 and 1 year of rigorous imprisonment for default.
So, earlier bail application was rejected?
Yes, my lord.
When it was rejected?
My lord, we see IA number 791 of 2019.
No, the order dated.
2010-2022.
No. 22. 17 for the expedite hearing of the appeal disclosure. Achha. So, कितने वर्ष हेलानी आपण रहिलेनी?
9 years, 4 months and some odd days.
हाँ, कितने?
9
years, 4 months.
मेरिट रे तो आपनकर बेल रिजेक्ट ही जाईची.
My lord.
मेडिकल ग्राउंड कौन है आपन?
My lord, he is suffering from various ailments. He had some infection, body infection, for which he was taken to the hospital by the jail authorities.
So you have not annexed any medical document.
We do not have any medical documents.
So what is your instruction on this paragraph number 3?
No IS of
Huh?
No IS of
Copy you have not served.
I'll serve another copy.
Give another copy and let you take instruction in this paragraph number 3. Say it is a deha kharap hoch kotha lagta hai. All right, IN number 2021 of 2024 is an application for bail. Learned counsel for the petitioner submits that the petitioner is aged about 76 years and he is suffering from various ailments, and he was also admitted to Anandapur hospital for the treatment, and his health condition is alarming. Stop. No medical document has been annexed to the interim counsel for the state submits that he has not received the copy of the interim application. Let a copy of the interim application be served on the land council for the state by tomorrow. By tomorrow, and the land council for the state shall obtain specific instruction on paragraph number 3 of the interim application to the concerned jail superintendent. Who jail achi?
Andhapur, my lord.
Andhapur jail. All right, matter to be listed on 9th of September. Ayush matter.
Deeply obliged.
Item 23.
Please, your lordship. My lord, in this criminal appeal filed IA for bail, my lord.
Let us supply the deposition copies.
Upon by Rachi, deposition copy. Pen drive next week as you. You have got the deposition copy with you.
Paper book.
Yes. You received the paper book just now. Land council for the state submits that since paper book has already been prepared, he may be given a copy of the paper book. Let the registry supply the paper book to the land council for the state. Matter will be listed next week for consideration of the bail application. Yes.
Okay. Item 24.
For may I please, my lord. Lord, the last occurrence, lordship directed to state to obtain the custody certificate, my lord.
Custody certificate or instruction about misutilization of liberty.
Lord, 2, my lord.
He was on entering bail from Procedural days which of days and surrendered on Procedural for days. ଜଣେ ଯାଇଛି ଦୁଇ ଜଣ ଯାଇଛି.
You have been granted interim bail also for a
yes,
period of 3 months. That is the
yes,
order 19/4/23.
Exactly.
Mr. Tripathi,
yes,
we asked you also to obtain instruction whether there was any allegation of misutilization of liberty. You have only produced the custody certificate, but not the other thing. They are from which police station?
Lord, Nabarangpur, my lord.
District Paparahandi police station. So you have sought for it or not? Get it?
Yes.
All right. The land council for the state has produced the custody certificate of both the appellants. Is taken on record. However, he submits that he may be given some further time to obtain instruction as per the order dated 12/8/2024 regarding any allegation of misutilization of liberty by any of the appellants. Put up this matter. 9th. Yes.
Item 26.
May I please, Your Lordship? I'm appearing through virtual mode, Your Lordship. On the last occasion on 28/2024, Lordship directed State Council to obtain instruction with regard to criminal antecedent, Your Lordship.
Cheese, not arsenic chance. Arsenic. 26 months. Acha. You want it day after tomorrow? 29. Madam, it will be taken off on 29 from this weekly list. Okay.
All right.
Item 27.
May I please, Your Lordship? I seek for an adjournment, Your Lordship, on behalf of Mr. Devashandas.
All right. Adjournment is sought for on behalf of Mr. Devasnanda. Put up this matter. Yes, next.
Item 28.
48 one petition is there that I will file my work.
Prisoner's petition has been received at Flag B for engagement of Mr. Sushant Kumar Tripathi in place of Ashok Kumar Das. Mr. Tripathi is present in court and submit that we will file VNAMA within
a week.
Within a week. It is this matter in the week commencing from 17th of September 2024 for consideration of the interim application for bail. Yes.
Item 29.
May I please, Your Lordship? My Lord, on behalf of Mr. Lalitendra Mishra, I am praying for 1 week time.
Right. Adjournment is sought for on behalf of Mr. Mishra. Matter is adjourned. Keep the date. Yes, next.
Oblige.
Item 30.
Please, Your Lordship. There is appeal bail, my Lord.
Number 2020.
Theater.
अच्छा theater movie. जुम्मन आर्टिकल.
Okay.
Item 31.
But Your Lordship, not drawing password for the day, Your Lordship.
Tomorrow?
Yes, sir.
51 matter. There is a direction to get instruction. Regarding whether any appeal has been filed by the state or not. Oh, it's case that case 5 number.
Yes, 5 10.
It's the report I sit from the TV matter. You want adjournment?
Password for the day, Your Lordship. Tomorrow, let's see.
8 of the Rocky Thangu, Tabi order. Yes. Keep it for now.
Let's keep it tomorrow.
This from the weekly district will be called on 28th of August 2024. Yes.
Item 32.
Yes, sir.
Yeah, please, my lord.
Yes, 29 days. That is the stamp report. You have filed the delay condonation application. What is the sentence in court?
Not true. I have some filings.
Mr. Counsel, have you aware that for what purpose it has come? There is a delay of 29 days and you have filed an application for condonation of delay.
Yes, my lord.
So, even the question of bail, etc., arises later on. So, we are asking you that for what offense you have been found guilty and what sentence has been imposed.
Yeah, 302.
302.
Yes, my lord.
And sentence is?
Life imprisonment.
Serial number 70 is an application for condonation pointed out that there is delay of 29 days in filing the criminal appeal. Since after going through the amendments taken in the interim application and hearing the land counsel for the both the parties, and since it's a case where the petitioner has been sentenced to life imprisonment, we are inclined to condone the delay. According to delay is condoned, is disposed of and admit for the trial court record. Interim applications for bail and stay relation of time to be considered after receipt of the trial court report. Yes.
Yes, my lord.
Item 33.
Life imprisonment. Yes. Life imprisonment. So, delay condone or admit are invested. Appeal memo along with the appeal memo. I would say prisoner's petition along with the copy of the judgment be handed over to the land counsel for this year. The action, the ready action. Oh, who ready to document?